we basically take another look at it and say, okay, substantively, what's changed? So today, we're going to talk about the owner contract and the general contractor relationship, as opposed to the entire suite of AIA documents. But the good news is that I think the consensus documents, which came out during the prior 10 years, have put pressure on the AIA to stop making a lot of the substantive changes that we've seen over the years and to try and make the documents more workable. So the goal of today, starting with Doug's presentation on insurance, and then I'm going to walk you through everything from proof of owner's ability to pay all the way through liquidated damages and chattel button it up with notice requirements, is to try and demonstrate to you how to make these contracts more effective in the administration. Because you've got a 40-page general condition in a single space. All of it seems overwhelming. Every time you're presented with an opportunity to review these documents, it's a daunting task. And so our objective today is simply to try and give you a checklist of the new changes, as well as remind you of some of the old things to make it easier on you. Thank you for listening to us.
Back to you, Doug.
This program is going to cover the gamut of the changes to the AIA documents. I'm going to start with the insurance exhibit that is connected to the A101 standard form of agreement in terms of how they relate to the new exhibit, but it's actually kind of an extract from the general conditions, the A201, more or less. And then Kevin and Chad are going to take us through the balance of these notable changes. I'm going to cover the insurance section. First of all, I think overall, from a 10,000-foot level, the changes are a big improvement over what's in the general conditions today. And we'll take you through some of the more noteworthy. The biggest difference is they sort of streamlined what remains in the general conditions, and they moved the bulk of it to a separate exhibit. And if you use these documents, or currently, there's typically there needs to be an exhibit because the documents themselves really don't allow for inserting insurance limits or various non-standard coverages that are available in the marketplace. And so typically, if you're using these today, there is a separate exhibit that somebody is making up, one of the attorneys on one side or the other. That's less than ideal because ideally, one of the advantages of using these documents, if both parties are amenable, is that they are, they have been sort of negotiated by all the parties to the construction arrangement, and that includes contractors, subcontractors, architects, engineers. Everybody sort of gets a say in it, although, depending on your point of view, the architects tend to get more say. So the one good thing about it is it's sort of the, perceived to be sort of the middle of the road, fair conditions, if you will. And so, one of the things we use it for, and, I'm an insurance guy, but I practice law on TV, right? Is we use it as sort of the baseline when folks come to us and say, geez, what do you think of this? What do we do with that? A lot of times, pulling out the AIA and saying, all right, well, let's start here and see what this says, and making a comparison is a really good place to get your head around some of the issues that might be impactful to you. So the insurance exhibit, one of the big things that it does is that it moves the builder's risk references from the general conditions to the insurance exhibit. And one of the things that you might want to get your hands on after this program is AIA's got a comparative document where they've taken if you're a license holder, I assume you guys got it from the database.
We can circulate that.
Okay.
Doug.
This is a really handy document. They basically take the old one and they line out everything that's been changed, and then, you know, they, just like they do in when you're negotiating a contract, and then they show the new language, and then the whole insurance exhibit's a whole new document unto itself. So it's included in that. And I've got it as we go through this. I've got the actual, you know, snapshot of the exhibit itself. But so the default position on the builder's risk is that the owner will purchase it. I think that's the same. That's a carryover from the current document. Of course, any of these things can still be negotiated and lined out and changed, right? So this is just where your starting point is. And, you know, as an insurance broker, we're sort of an advocate for our clients, like the attorneys in the room are advocates for their clients. So depending on which side of the fence you're on, whether you're an owner or a contractor, if you come to me and ask, should I, you know, volunteer to provide this, or should I accept the owner's, you know, coverage? A lot of people default to, we've found over the years, a lot of people default to the position that, well, you know, we just let the owner buy that. That's their thing. And there's really some key language in this document that I think really is germane to that decision point, because it essentially, there's a waiver of subrogation in the agreement, and that continues to be in the general conditions, and it's pretty similar to what it is in the current version. But one of the things that paragraph says is that, you know, we waive subrogation against each other to the extent that the damages were caused and are covered. I mean, the damages are covered under the builder's risk program. Well, one of the things, if you don't take anything else away, one of the things you take away from this program is not necessarily an AIA change, but builder's risk is a very customizable coverage. And so that, because it says that, and because you're giving mutual waivers to each side of the contract, the broadest coverage that you can get is in your best interest as the contractor. And so just defaulting to letting the owner make that decision and buy that coverage, we would not advocate for that. If at a minimum, you should insist before, you know, you close a deal that you at least have some input into that coverage. And we have worked with a number of our big trade contractors on this, and they never did it before. We got them doing it, and they've really, it's been impactful to them because they realize, oh, geez, all this stuff is negotiable. And the broader that coverage is, you could potentially, you know, if you don't buy an optional coverage and something happens and you have, you know, this waiver language is kind of meaningless, because if it's not covered by the builder's risk, then you're still fighting it out. But if everybody's transferred the risk to the insurance company, that's, to us, that's a positive regardless of which side of the transaction you're on.
Hey, Doug, can I point out one thing that is a little different, relating exactly to what Doug just said? If you look at what's in quotes here, they're two small words, but they're words that go exactly to the heart of what he's talking about. That all risk builder's risk policy matters when you talk about owners, because what owners are going to want to obtain is they're going to come back and say, well, I already have a property insurance policy. And since I have a property insurance policy, I don't need a builder's risk policy. And historically in the AIA documents, that's what it contemplated, was a property insurance policy. The problem is that a property insurance policy has gaps in it. And the gaps are gaps in coverage. They are things that won't be covered that'll create the subrogation problem that he's talking about. And so always the solution that I was faced with drafting these contracts over the years was we always had to go back to the owner and say, well, you've got to get a functional equivalent of an all-risk property policy. And this is an example of the AIA appreciating that kind of negotiation over the years and changing that. So again, the one takeaway out of insurance is that all risk matters, because if the owner's getting the insurance, even if it's property, they have to get a rider that covers for all risk.
That's a great point, because I would add that the term all risk is more or less meaningless. Okay, because there's not you can't buy an all risk policy in reality. It's This is very customizable, non-standard coverage. And that's one of the things that I think really throws people that are parties to this, because they think, well, you know, the owner's got the same requirement I've got. It's an all-risk policy. Yeah, that's not the reality of the world. There is no such thing as an all-risk policy. That's sort of a generic term that's thrown around to encompass, you know, the standard coverages of a builder's risk policy, which are, you know, the things that you're familiar with, right? Fire, windstorm, potentially flood, that's an option. Earthquake, that's an option. There's all kinds of options. But, you know, fire, windstorm, vandalism, theft, the main ones, that's sort of the, you know, what you get if you're just talking about an all-risk policy. So this is definitely something that I think the way they've reformatted this exhibit is going to be helpful for this discussion, particularly for a less sophisticated party in the transaction. But this is something definitely worthwhile talking to your broker about and getting more familiar with this. In the exhibit itself, there's a number of sort of check boxes where they do describe some optional coverages that in the current document don't exist. So it's definitely a better tool to lead you to a better outcome the way it's presented. I think this is a standard position. This is a default position. If the default position is the owner buys this coverage, the owner will take the deductibles. That's probably one of the most negotiated ones out there, right? Because the owner always wants you to take the deductible if you're a contractor. And then it's got a whole bunch of these optional, more esoteric coverages that are not, you know, typically, if you're not real familiar with this stuff, they're at least leading you to the, you know, the major ones that you ought to be considering. Go ahead. They've changed. This is a change. The old document that's in use currently references a 30-day notice of cancellation. In the certificate, this has been a real controversial area of insurance, particularly in Georgia. There's been a ruling on this. You know, most carriers will not, you know, there's no certificate does not allow for that anymore. The publisher of the standard certificate and the insurance commissioner have made decisions on that, and so you can get an endorsement, but that's not universally offered, and so they've recognized, I think, the practical realities of the marketplace, and they've changed that. So now it doesn't speak to that 30-day notice of cancellation. It talks about a notice of 3 days that each party owes to the other if they become aware of circumstances whereby their coverage is going to cancel. I mean, typically that's a result of an insolvency or something. So those provisions are kind of like, yeah, you need to have them, but you know, I don't know that they're really all that significant. In the exhibit itself, the deductibles are disclosed, so that's a good thing too, because we found that in a lot of situations where people again default to the GC or the owner to buy the builder's risk, and they're not even aware of what the deductible is because it was the contract doesn't say anything. Well, if you don't, in those cases, if you don't ask for the deck pages and a copy of the policy, you could be sorely surprised that when the claim comes and you realize that the buyer of the policy specified $150,000 deductibles, which I had recently happen after doing a class like this. And literally the following week, somebody sent me a builder's risk policy and said, "Hey, take a look at this with Scott Griffin." and it was literally, the deductible was huge, and they were able to get with the owner and negotiate that. So this contract, if they're using this exhibit appropriately, should give you some disclosure on that. And then the exhibit also specifies the penal sum of the bonds. I don't know that's been a clarity thing. I think that's good as well. We talked about this. The new Exhibit A moves most of these requirements out of Article 11, although there still is an Article 11, insurance and bonds in the general conditions. It's just a lot more streamlined. And this is a big one, because this is one of the advantages of having this exhibit is, and I think that was by design, right, is that you'll have the ability to just extract this, send it to your broker. And that's what we would recommend. We would not recommend you try to interpret this and tell your agent what you need. That would definitely be the best outcome. In some contracts, they'll also include a certificate of insurance that looks like what they want it to look like. Obviously, we'd recommend you share that with your broker as well. That's not required here, but that's just something that we see commonly trying to clarify this stuff. Yeah, I think we've covered all that. Notice of cancellation. We touched on this. Owners must notify the contractor within 3 business days of becoming aware of a cancellation. That's both parties. And then it outlines what your rights are under the contract in the event that occurs. Again, you don't really see this typically unless somebody goes broke. So, you're already in the soup at that point. Next one. And then this is an actual snapshot of the Exhibit A. And you can't really see it very well, but we'll send this to you, but you can click through it and kind of see how it's laid out. This looks a lot like the general conditions, used to look, paragraph 11. As we said, most of it's been moved into here. And here's where you see some of these unique specifiable coverages under the builder's risk. So there's things like loss of use, business interruption, delayed completion. So, you're building a food plant. Fire burns it down. They're going to, they've got really short deadlines. They've got income being held up. You can actually insure that. And people say, well, why do I care about that? That's the owner's position. Well, my point of view is the broader and the better you can make this, the fewer headaches you're going to have to deal with. Because if a client could get this coverage at very low cost on the front end, in fact, the cost of this stuff has probably never been cheaper in my career, relatively speaking. There's tons of capital in this business, and there's lots of folks in the builder's risk, property, in the marine line. It's a short tail line of coverage, right? It only lasts a year. It's not something you got to make a GL bet on. That's going to, you could be exposed to loss for 10 years. So there's a lot of players in this right now, and that's what that's a good takeaway as well, because this stuff can be bought for next to nothing if you do it up front, right? You can't add this after the job starts. It doesn't work that way. But if if you have a very robust specification, you go into the market, you can get this stuff for almost no difference in the rate, right? They'll give you that 5-cent rate, whether these are in there or not. And so it's just kind of, in my opinion, the more you can get of this, the less the likely outcome is going to be smoother. Because if somebody's got an uninsured loss that could have been insured for very little money, and you're, in a construction arrangement, right? At a minimum, the owner could have a budget problem, right? So, not saying the project gets shelved, but if you had a loss and it was uncovered on a builder's risk policy, the owner can have a budget problem because you're gonna have to be paid again, right, to finish the work that needs to be repaired. This can help you avoid that. And so some of the other stuff, expediting cost, right? You're installing special equipment. It takes 6 months to get it. Well, it just burned up in a fire. Guess what? That just extended the schedule, right? You can insure the cost to pay somebody extra to make it in 2 months or whatever is physically possible. So that's just something really worth having. Ingress, egress, soft costs. Owners, particularly developer owners, that can be a really big deal. That's where if a project burns and the schedule gets extended, you can have all kinds of extended fees and costs, permits, architecture fees, taxes, interest on loans, all that stuff can be insured here. And this is a very negotiable type of coverage too. So, the underwriters of this type of coverage, it's something that's kind of loosely defined, and it's almost like if you can think of it, they can insure it. It's really negotiable. So this is all good stuff. There's cyber liabilities at the bottom here. That's another one you hear a lot about. Builder's risk exposure. That I think that's less germane, but that's certainly a coverage that if you don't have, you need to talk to your broker about. That's a coverage for somebody hacking into your system, which I guess with business building modeling and all the technology that's being brought to bear, that coverage has gotten more important over the last few years because people are accessing each other's networks, right? To share the drawings and the data and all that. So that coverage is becoming more important. This is, again, most of the stuff is coming over. This is new here. This is where they're specifying the coverages. They're leaving blanks for the limits on the GL. In the current version, there's no place to do that at all. It just says, oh, you need GL as prescribed. And there's not a document that it even refers to currently. So you've got to kind of come up with that. Go ahead and click. This is what you see currently. kind of talks to coverages, but it doesn't specify limits. So you've got here's workers' comp. They allow for you to fill these things in and customize them.
Doug, can you go back one? I just want to
Sure.
something out. So we kind of generally know what this means, but until you've actually been through a negotiation with an insurance company as to how they're going to interpret bodily injury and property damage, I want you guys to appreciate that this is the limit of the coverage that you're obtaining unless you go to the prior slide and you check all those boxes. And the reason what the AIA has changed with the prior slide with all the boxes is to basically put you on notice that if you don't check those boxes and you don't allocate that amount, you're effectively potentially uninsured for those. That doesn't mean you're without risk, because those indemnity provisions that exist in 3.18 of the general conditions are going to remain. And those often get negotiated even broader, such that the indemnity is not limited to bodily injury or property damage. That's something that we seek to limit. The standard AIA language limits it to that, but if you look at the revisions common in every owner contract that I see, it's broad form indemnity. It's words like arising out of your work. Well, arising out of your work can be cybersecurity. Arising out of your work can be all of those boxes like business interruption. If you have an asbestos problem on a project and you cause that plant to shut down while they correct the asbestos problem, you're going to have business interruption. And I know we have industrial folks in the room. Those are things that you probably were considering. One thing I like about this change in AIA is they're actually affirmatively giving you the checklist to consider it. And then it becomes three folks that need to talk about it, at least. Estimating, because you need to figure out what your cost going to be of your project if you estimate by including this, your insurance broker, and possibly your legal counsel. I mean, those are the folks that need to weigh in on it in terms of the selection. The nice thing is that the AIA is recognizing that there are available ways to protect yourself from those risks, and they're giving you that list.
That's a great point, because a lot of times on the general liability, people assume, well, that's general liability. It covers me for just about anything we can do. Well, really, that outline that he was pointing to there is really what it's defining essentially what it covers you for. And so, like, if there's a pollution exposure, to Kevin's point, on a project, general liability is not going to help you. Well, that's one of the itemized coverages that they're at least bringing to the table, like the cyber and some of these other things, where you can buy those extensions and cover that if the project requires it. Not every project's going to have a need for it, but more and more, particularly that cyber piece with the technology exchange that's going on sophisticated projects, that's more and more important. It goes on. I mean, there's other specialty coverages right here. Talks about maritime liability. That's another one. Like if you're working on a dock or a bridge, there are specific coverages that you, as a general contractor, may not encounter but once a year. Well, you can purchase that, but typically, you may or may not have that built into your program now. So that's bringing those kind of things to the table. Go ahead and click that. And then it gets into some other that are fairly common add-ons to projects. If you're working near a railroad, there's something called a railroad protective. You don't have automatic coverage for that. In fact, there's exclusions in your GL that are problematic around that. And so, it speaks to those. So it's a lot more specific. It's a lot more customizable. We think it's going to be a big improvement. Yeah, it's just talked, this one, specifies the bond. And the default position is AIA bonds, as you can imagine. More and more common folks have their own bond forms. Caution on that, right? You want to understand what the bond form says, because it's just as important as your contract, and they vary significantly. So the AIA form is a sort of again, the neutral place to start of all the parties. The sureties negotiated that, the owners, the contractors, but more and more often, particularly if you're a subcontractor, big GCs will have their own form, and you want to be familiar with what it's calling for, because it could be significantly different than AIA. Any questions on any of that? We'll get these documents to you, and I think it'll be really helpful. Thanks. Kevin?
Thank you, Doug. Okay, so I'm going to take you through everything but insurance. And let's see, there we go. Evidence of owner arrangements is obviously something you guys have seen before. This is a provision that existed in the 2007 version. And the reason that it's important is, well, I think everybody figured out it was pretty important in 2008, right? Because all of a sudden, everyone's gung-ho, they've allocated all of these resources within your department, you spent all this time estimating, and we forgot to ask the most important question. Does the owner have the money to do this job? And if the owner did have the money to do this job, well, what are the impediments going to be to the owner continuing to fund this job as we move forward? That's what the AIA is talking about here. It's more comprehensive language that they have put into this document. Essentially what it's saying is, and this is the takeaway for you, not all that different, but previously it said the contractor may request. Now it says, upon written request from the contractor, the owner shall furnish to the contractor financial information. So takeaway for today is simply that as part of your overall operational checklist for your project, you need to send a written request to the owner for the financial information, and they then have an obligation to provide. More importantly, what that language says, which I know nobody in the back of the room can read, but I'm going to read it for you, is it says that the contractor has no obligation to commence the work until the owner provides the evidence of financing. Often I put the same kind of language in subcontracts saying, you don't give us your insurance certificate and your endorsement, then we don't have an obligation to pay you. That's the only way, unfortunately, that we can kind of get people's attention in the contracting world, and that's exactly what the AIA is doing here. It's basically saying, look, Mr. Owner, give us your evidence that you have the ability to fund the project, or we're not starting your job. It also goes further and says if the commencement of the work is delayed, then the contract time is going to be extended accordingly. I might argue that's insufficient because you could have delayed general conditions and costs, but it at least gets you to contract time, if not contract sum. Any questions on that one? That is obviously a great question, and obviously one that is capable to interpretation. You as a contracting entity have to decide what you deem to be sufficient. Obviously proof of lender funding, proof of draws, things of that sort are the kinds of things that I've seen. I've also seen and had some clients who absolutely insisted on very detailed requirements of what that means. But in general, that's going to be in the eyes of the beholder.
There's actually an AIA document that outlines a request for that we've used. I want to say ask for a lender letter.
Yeah.
I mean, at least that would be a starting point. That's what I've used in the past.
I want to see lender letters. I'd want to see proof that if there's an equity contribution, that equity contribution's been made. I think that's probably the biggest danger, to answer your question, is that it used to be 80-20 in terms of the amount of financing. Obviously, those percentages have changed in terms of what's required to do these deals, depending on who you're dealing with in terms of the development world. And if there's a substantial equity contribution that's required, you need to make sure it's been made. Otherwise, you have an underfunded project from the jump. Okay. We talked about this one, which is the procedure, refusing to proceed, but it also is that you can suspend the work if there's a basis for doing that. And that's saying that if there's a basis for requesting additional proof of financing as your job goes forward, and they have refined that to be clear in saying that it's failure to make payment to the contractor or there's a reasonable concern regarding the ability. If they don't provide that evidence within 14 days, then you can suspend the work, and again, you get the same kind of extension of time. I can tell you affirmatively that you are going to get a lot of pushback on trying to suspend your work in the middle of the job by the owner, and that your expectation leaving here shouldn't be that this is gospel and that this won't get negotiated out of your contract. I negotiate this provision on a regular basis with clients, and they basically say, well, if I'm not paying you, you have other remedies. There's some truth to that, okay? But nonetheless, there is a requirement for this to say, okay, well, look, the idea should be that if we've got financial problems in the job, we ought to try and come together and sort that out. Certainly, I know we have surety folks in the room, and that's what they would want to do. They would want to say, tell us if we've got some financial issues so we can try and figure this out and have pre-default meetings rather than getting to the point of some kind of battlefront negotiation. And that's the goal of all of this, okay? So if you are going to negotiate it, you still want to push on them to say, fine, but non-payment doesn't tell us enough, because non-payment means we're already 30 days out. We've already got commitments to subs who aren't getting paid, and we don't know if you're actually going to fund. So those are things to consider as you negotiate. Last point, provides for time extensions and adjustments for delays, which is something that is completely new. In any negotiation, I would absolutely tell you that you don't want to drop that provision, because just like anything else, I mean, it's routine for us to say in the 101 provision or the 102 or 103 where it talks about when you're going to start, we always negotiate when is the contract going to start this job and what are the conditions for doing that. You've got to have a building permit, obviously, but you need other things. Proof of financing is absolutely one of those, and I wouldn't back off of that. And I think this gives you the authority not to back off of it. Any questions on this before I move to the next section? All right, supervision, construction, procedures. I find this one to be particularly odd. Any design professional will tell you that, and they will go to their death telling you that it is the contractor's responsibility for means and methods. The design professional has no responsibility for means and methods. We've all heard it, right? And conversely, all contractors will tell the architect, we have no responsibility for design, which should be true as well. This is the provision that says, if for whatever reason the architect specifies construction means and methods, how is that going to be handled? In the 2007 version, it allowed the contractor to decline, and then if the owner directed, then there was responsibility. I personally favor this provision to the change, because that basically says we're not going to follow your means and methods. If you tell us to do so, Mr. Owner, you're now responsible for means and methods. Because I think ordinarily the contractor ought to have control of means and methods for a lot of reasons, not the least of which is the logistics of the job. The change in 2017 says that it's now the burden and risk to the contractor to propose safer alternative means and methods. So you're not going to get out from under the means and methods under the 2017. And it's your obligation, if you don't like the means and methods, to say, we're not doing those, we're doing these. Okay? The takeaway here is, just like in 2007, you have this provision in the same section. It's in section 3.3. There's that language in if that is happening, you need to suggest alternatives. I want to make sure everybody's clear on that. Number one, you have an obligation to look at those plans and specifications, and your subs must do the same, and they must tell you what they look at that seems to be a problem before you go into contract. I know it seems obvious, but we all know that subs don't necessarily do that. They sometimes show up raising their hand afterwards going, geez, I didn't realize this was going to happen until I got out in the field. That could be a problem. The means and methods is simply an extension of that. Questions? Sir?
I'm just going to design build scenario where the plans aren't finished when you enter the contract.
Yeah, I think that, well, first of all, this is not a design build contract. So this is purely a specs and your building plans and specs contract. So the language would negotiating a contract where a bunch of guys out of Boston seem to think that working on Sundays down here in Georgia is no big deal, and city of, Roswell feels differently about that. So could be a means and method. I don't think so, though. Personally, I think means and method is really the techniques for how you're going to do a particular task of construction.
And the other one is more related to the provision of contractors responsible for not responsible.
Right.
What about performance-based pay? What I mean by that, I had an issue on a job years ago where there was a performance tag on a storefront or a curtain wall system on an office building. And the architect just decided he wanted to design it, and it was ballistic rated with basically there was steel that had to be added to the storefront that wasn't shown on the drawings or anything like that, and because of the performance-based spec, it held up liable for that.
Correct. You've raised an entire different seminar that I give on the dangers of performance-based specifications deriving out of what often we see in like EPC contracts, engineer, procure, construct, but performance-based. The only thing I could tell you in this short period of time about performance is it is an extraordinarily dangerous activity. It can essentially make you responsible for not only the design of the building, but essentially the machine functionality of the building, and it needs to be heavily negotiated and dealt with. If it's not, you have a risk that is profound. And curtain walls is an obvious example because curtain walls is like retaining walls. I mean, it's not uncommon that a curtain wall is a design build within, okay? Different provision, but I think it's 1210, somewhere around there, 1210, where it talks about you have no design responsibility, which is in the standard 207. It's also in the 217. But if you read that provision, there's language in there that needs to be taken out. The language says in this provision, apologize for not recalling exactly, but it says that you're only responsible for design to the extent it's specified in plans and specifications. It goes on to say, or unless such design would be necessary for you to carry out your work. It is that language that I strike out of every contract because that has no parameters about what it means. If they want you to take on the design responsibility and they want you to take on the performance responsibility, there's a cost to that and there's a process for that. Not this provision. Anything else? Okay, so you can just see this is the markup. We're going to we'll get Katie to send you the kind of side-by-side markup so everybody has it on the list of attendees. All right, next one. And this one I like a lot. Instead of the prior termination for convenience provision that talks about you get paid for overhead and expenses and a lot of terms that sound like they might mean something that the lawyers debate the meaning of all the time, 2017 cleans it up. And what it says is you now get cost attributable to termination of subcontracts, which is obviously going to be demobilization and cost of work performed, and you get a termination fee. And this is what everybody who's taking notes needs to write down. This is a new requirement for your checklist of what you need to be doing, which is you need to put a termination fee into your contract. Why is this a good thing? Because a termination fee that is negotiated in a contract is absolute, subject to what I'll talk about LDs in a second, liquidated damages. But it is absolute. It's not something that's open for debate. And if you get terminated for convenience, and there are certain retailers out there that I've seen this a lot, where they, for whatever reason, they'll enter into contracts. The contractor completely gears up, operates for a month or two, and they say, we've revisited our plan, and they terminate for convenience. And there are substantial costs associated with termination for convenience when you have that. So give some real hard thought in your operation to the right termination fee, and it could be scalable. It's not defined here. If you terminate us in the first quarter of the job, the termination fee might be X. If you terminate us in the second quarter, it might be Y, because you are, in fact, losing opportunity if you are terminated for convenience. And I am here to tell you firsthand, it is going on in your marketplace. Hadn't seen it in a long time, but I am seeing it particularly in the retail sector. The one caution that I give you is that because it's a termination fee, it's basically a liquidated damage provision, which you're familiar with in terms of delays, right? And the standard for liquidated damages is simply some language that you need to put into the termination fee that is similar to what you see in the liquidated damages. And that language is going to say that it was difficult to estimate, but it's been reasonably done, that type of language that is in every liquidated damage provision you've ever seen, and you've skipped right by it because it looks like a lot of lawyer blah, blah, blah. It actually has meaning to the courts, has no meaning to you. But it has meaning to you here because you want the same language in the termination fee, okay? The AIA doesn't tell you to do that. HPW is telling you to do that because that language is going to likely be important in terms of the ultimate enforceability for something that, as we sit here today, has not been tested. But it's our job to look forward past that and say, okay, if it gets tested, what's going to happen? Questions about that? All right. Liquidated damages is a provision that we've all seen get inserted into contracts. The difference is now that the AIA has recognized that people keep marking up their contracts to insert liquidated damages, so there's just simply forward thinking and inserting it in there. And so the one difference is, and this is one that I think is deeply troublesome and should be heavily negotiated, this says that the owner is not required to submit a claim as a precondition to assessing liquidated damages, that they can unilaterally assess liquidated damages. Now, I have this exact scenario headed to arbitration in April, in which this took place without this language. What's the problem? The problem is that in that case, the general contractor did a comprehensive critical path schedule analysis to determine that there were over 150 delay days caused by the owner's failure to deliver required materials that were a precondition for the work going forward. The owner's response was not to conduct a schedule analysis. As a matter of fact, they just tendered an expert with no schedule analysis and say, yeah, we're asserting liquidated damages. And we're unilaterally allowed to do that. This provision arguably would allow an owner to get away with it, to unilaterally assert liquidated damages without performing a critical path schedule analysis as to what was the precipitating cause of delay. So about all I can tell you about this provision is that if you come talk to me about it, I'm going to tell you we're getting rid of it. We're going to revise it because this cannot be the case. The idea behind construction is not to put all risk on the contractor, and I represent owners, and I tell them the same thing. The idea is to ultimately achieve an effective project. And if you try and push everything down on the contractor, who's going to push as much as it can to the insurance, we've talked about, but can't push all of it, you're going to have problems in the project. This is simply a fairness issue. I don't mind if they have a right to declare liquidated damages, but they ought to have an obligation to come forward with a critical path schedule analysis that demonstrates that the contractor was the sole basis of delay if they're going to do that. And that's not always the case. Okay? Questions about that before I turn it over to Chad? Well, I want to thank everybody for staying awake. This is one of the less scintillating topics we get to talk about, but is nonetheless quite important. And with that, I'll give you my colleague, Chad.
We're almost there, guys. So one of the changes that they made in the 2017 documents is with regard to notice delivery methods. They've recognized that we're now in a modern era where we have electronic communications. They allow notices, most notices, to be sent by electronic transmission. Now, of course, they don't define what electronic transmission is in the 201. They had included in the digital data protocol exhibit that the AIA has made part of the agreement. I know most projects, that digital data protocol exhibit is a little complicated. It's a little much. So a lot of folks have struck that exhibit. And if you do, one of the things you need to make sure you do is define what electronic transmission means. You have to say it's by email, who you're sending it to, who's the recipient of that notice, and if you want to read receipt, if it has to be flagged, something to draw attention to the notice so they know that it's a notice under the AIA documents. The one provision that they have not changed for electronic transmission are notice of claims. They believe that a notice of a claim is special, that it should have some more attention drawn to it. So they don't allow it to be sent by email. They still want personal delivery, certified mail, or overnight courier. You know, in practice, is this a good idea? It might not be for your company. You might want to have the ability to send a claim via email with all the attachments. You know, a lot of times personal delivery, certified mail ends up just being a barrier to entry for the claim, and it's a gotcha provision. So, you know, one of the things you might want to consider when you're negotiating the contract is this something you want to allow to be sent, a notice of claim to be sent electronically by email? And you know, it might be something you want to do. Any questions on that? How many of y'all send claim notices by email? Show of hands. One. Lien indemnity. This really isn't a controversial change. I think most owners were including this in their contracts already. There you go. So it's your standard indemnity provision says if somebody files a lien on a project, the contractor has to indemnify the owner for those liens. Contractors always mark this up. They put in the language provided the owner's paid you. You know, we're not going to indemnify you for a lien if you tell money on us and we're unable to pay our subcontractors because you're holding money. The AIA recognized that. They included the common carve-out. And ultimately, we think this is a fair provision that shouldn't be changed too much in the document. Warranties. Not too many changes. The one thing I want to note is that the warranty provisions in the AIA 201 appear in two places. And when you're looking at warranty in the 201, you need to look at two separate provisions. One is in section 3.5, which is your standard materials and workmanship warranty language. The other is in section 12.2.2, which is the repair or replace language. That's the correction period language. So here we've got section 3.5, which I'm sure nobody can read, but 3.5, this is the standard warranty, workmanship, materials are new, and will be free from defects. The thing to note here is that this language does not actually contain a time limitation. So in 12.2.2, there's a time limitation on your correction period, but there's no time limitation on the actual warranty itself. So if you want to make sure that your warranty is also time limited, you need to insert that language into this provision as well. This would be something that the owner is going to negotiate with you, and you'll likely get some pushback on. But you'll see the correction period, the period in which the owner can then say, you've reached your warranty, come out and fix it, is limited to 1 year from substantial completion. So that's where the time period normally does come into play, is in that repair or replacement context and not in just the warranty itself. One of the other changes the AIA did, it's minor, but it's something you're going to want to pay attention to, is they took out the word written in front of notice. They've done this in a couple of places in the documents because they've centralized the definition of notice somewhere in the 201. I think this is a bad idea. You need to add it back in wherever they've taken out the word written to make sure that you're clearly specifying that you want written notice of defect, not just an oral or verbal notice. It can't just be a guy picking up the phone and calling your front desk receptionist and saying, hey, we've got defects on our project, and expecting that to be sufficient notice. The other thing to do is make sure that when you're this notice, one of the common modifications we do is to make sure you specify what the notice has to contain. So you want to make sure they're specifying what the specific defect is, what the work is they want you to repair, so that you know what you're looking at when you go out there, and it's not a broad notice of all defects that could really run amok. You want to limit what their warranty claim is for. Covered that already. Finally, we've got the initial decision maker provision. The AIA did make some changes. Unfortunately, they didn't make the changes we want, which is to just get rid of the whole process. In our experience, the initial decision maker really doesn't help in resolving any disputes. It just is a barrier to entry for your claim. It costs them more money, it delays you, it slows you down, and it ends up making the dispute more complicated. Instead of getting rid of the initial decision maker, which is the architect, in most cases, the AIA added provisions to insulate the architect and protect him. They say you've got to be impartial, and as long as you make a decision in good faith, you're not going to face any liability for it. Now, the idea was, well, we'll encourage architects to actually issue initial decisions that mean something. I still don't think they're going to at the end of the day. They don't want to take a stance when the owner's paying their bill. The other is the decision-making authority of the initial decision. They've limited only to claims under the contract as that is defined. They also cleared up a circuit split on the issue of when you actually have to submit it to the initial decision maker. What they put in there now is if the claim arises prior to the expiration of the correction period, 1 year after substantial completion, the initial decision maker has to receive the claim and issue an initial decision. If it arises after the expiration of the correction period, the initial decision maker process goes away. That's a good change in the sense that it has eliminated the initial decision maker process for certain claims, but ultimately we recommend striking the entire process because it really is not helpful and ends up being a barrier to entry to resolving your disputes. Any questions? Well, that concludes my portion of the presentation. Doug, do you have further remarks?
I do. Thank you, Kevin and Chad, for for joining us this afternoon. Very, very insightful. Please keep an eye out. Our next lunch and learn is scheduled for Tuesday, April 24th, and we're going to be covering recent tax law that passed through the Congress. We had the preview program before it had passed. Now that it's passed, the tax advisors are getting some time to study it and a little more clarity around it. And our speaker is going to be Andy Starnes, who's a partner over at Moore Colston, a really long-time friend of the firm, very knowledgeable of tax matters, and I'm sure it'll be worth your time if you have time that day. Please come out and join us. Thanks so much. Appreciate it.
Perfect. Great. Thank you.
I hope it was helpful, Sarah. It's good to see you.
Yeah, you too.
Yep.
I will. Well, he is people are